All rise. Veuillez vous lever. Please be seated.
Ms. Nikolic, good morning to you. Oh, good afternoon now, yeah.
Dobar dan, gospodine predsjedavajući.
Good afternoon, Mr. President. Good afternoon, Your Honours. And good afternoon to all my colleagues in the courtroom.
Predsjedavajući,
Mr. President, I have the honor to address the trial chamber today and formally introduce the closing arguments on behalf of the Drago Nikolic defense. I'd like to avail myself of this opportunity to say that it was a great privilege to work here and on behalf of our client before this trial chamber over the past 3 years. Your patience and the way you led these proceedings have facilitated our work a great deal. This case, although it's not the first I've worked on before the International Criminal Tribunal for the former Yugoslavia, will forever remain in my memory as one of the most difficult and most challenging in my legal career. Our closing arguments will consist of 5 sections in the following sequence. Section 1, general remarks. Section 2, the duties and obligations of Drago Nikolic. Section 3, evaluation of the evidence in the case. Section 4, the prosecution case against Drago Nikolic. And Section 5, the character of Drago Nikolic, and final remarks. My colleague will address you and cover the first 4 sections, and I will finish off with Section 5. Before I turn the floor over to my colleague, Mr. Bourgon, I would like to thank, on behalf of our defense team, all the interpreters, all the registry staff, especially the Victims and Witnesses Service, because without them, a trial like this would not have been possible. Thank you, everyone, and now let me turn the floor over to my colleague, Mr. Bourgon, who will start our closing arguments.
Thank you for your kind words, Ms. Nikolic. Mr. Bourgon.
Thank you, Mr. President. Good morning once again, judges. Good morning to all my colleagues in the courtroom. Mr. President, I have the honor this morning to address the trial chamber with respect to parts 1 to 4 of our closing arguments on behalf of Drago Nikolic. Before I begin, I wish to join my colleague in saying that it was both an honor and a privilege to appear before you during the last 3 years. I also wish to join my colleague in expressing my gratitude to the interpreters, the stenographers, as well as to all the registry support staff. Before I go to the text that I have prepared, Mr. President, there is something that is striking to me after listening to both my colleagues making their arguments, or their closing arguments. The word genocide has not been pronounced once. And to me, this is striking. It is firmly our position, Mr. President, that the events which took place in the area of Srebrenica, as well as in the area of Zvornik, despite the fact that these events were atrocious in character, that these events do not amount to genocide. And I hope to have the time to make my arguments before, or at least to make my case during the presentation of these closing arguments. And I'm sure that if my colleagues did not address the issue, it's not because they do not believe it, because they have the same position as we do, that this, despite its unlawful character, is unlawful and atrocious character, was not genocide. That being said, Mr. President, let me begin by saying that, as mentioned by my colleague Zivanovic, we respectfully take the view that 2.5 hours is a very short time in which to attend to all of the relevant issues we'd like to address after a 3-year trial. Of course, we do understand that the trial chamber is already in possession of our final trial briefs, which sets out in detail our submissions regarding the charges laid against Drago Nikolic and the evidence that was adduced at trial. Nonetheless, we respectfully submit that the time allotted is insufficient for the purpose of addressing all of the prosecution's submissions, both in its final trial brief and its oral arguments. Accordingly, we will endeavor to address only the most important prosecution submissions, hoping that we will have the opportunity to answer the same questions which were asked by the trial chamber to the prosecution in the event these topics are not covered sufficiently during our oral arguments. Mr. President, the time has come, 3 years and 2 months after the beginning of the proceedings against the 7 co-accused in this case, to address the trial chamber for a final time. To say that this was a long trial would be an understatement. I must admit in this regard that recently, when I was cross-examining witness Sreten Milosevic a few weeks ago, I happened to look at the screen before me, and I saw a man with white hair asking questions. And that took me by surprise, because I did not have the hairdo of Drago Nikolic when this case began. Nonetheless, the hairdo of Mr. Drago Nikolic, which is quite distinctive, was not sufficient for witness PW 102 to notice it when he met, allegedly, Drago Nikolic at the Standard Barracks. Beyond any doubt, Mr. President, that visit never took place at the Standard Barracks, as argued in our brief. On a more serious note, I would like to address the testimony of Sreten Milosevic immediately, because his testimony in this courtroom is one of the differences, or maybe one of the issues which highlights the differences between the prosecution and the defense on behalf of Drago Nikolic during these proceedings. You may recall in this regard that Mr. Milosevic was on the prosecution's Rule 65-ter list of witnesses when this trial began. However, as for what happened to a number of important witnesses on its list, and I will come back to this later, Milosevic was withdrawn from the prosecution's list because there was something in the evidence that he could provide which did not match the prosecution's theory of the case. Now, we saw this when Milosevic testified before this trial chamber, and all the gaps that he was able to fill, all the gaps which had not been filled by the prosecution. Of course, the prosecution is entitled to withdraw witnesses. But when such witnesses are critical to the understanding of the events which took place in July 1995, then it is the trial chamber which is deprived of relevant and probative evidence. Mr. President, this trial chamber had not heard any of the officers who were called upon to exercise the function of brigade operations duty officers during the critical period from 12 July until 17 July. Admittedly, we had some evidence pursuant to Rule 92 bis or 92 quater of Bojanovic and Maric. And of course, the evidence of, did I refer to a witness that was, sorry, I thought I made a mistake by referring to a witness who was not public. And of course, it is a public information that Dragan Jukic, who was Brigade Operations Duty Officer on 14 July, refused to testify in this case. In these circumstances, we respectfully submit that it was the duty of the prosecution to call Sreten Milosevic, who was on duty on 13 July. This is the basis of the prosecution's case against Drago Nikolic. Yet the prosecution decided to withdraw Sreten Milosevic. The position adopted by the defense team of Drago Nikolic in this regard was very different. We did not hesitate to ask the trial chamber to issue a subpoena against Sreten Milosevic to ensure that his evidence would be before the trial chamber. We knew that by doing so, he might react negatively towards Drago Nikolic. But our priority since the beginning of these proceedings has been to ensure that all reliable and relevant evidence which could show the true involvement of Drago Nikolic in these events would be before the trial chamber. 3 years ago, Mr. President, on 23 August exactly, 2006, I had the honor to address the trial chamber and to make an opening statement on behalf of Drago Nikolic. In preparing for these closing arguments, of course, I read what I had mentioned at that time. What is striking in this regard is the fact that what we said 3 years ago is exactly what we did during the prosecution case in chief. We challenged the evidence which was adduced by the prosecution. What we said 3 years ago also corresponds to the evidence we adduced during the case for the defense of Drago Nikolic. You may recall in this regard that, as promised, the case for Drago Nikolic lasted no more than 3 weeks, and that each witness called had a specific aim which could easily be identified with the view to answering the prosecution's case. And then again, what we said 3 years ago in the opening statement is also reflected in the Nikolic final trial brief. Contrary to others, and despite the manner in which the prosecution presented its case, and I refer to the prosecution adding new documents not included on its Rule 65-3 list of exhibits on a daily basis, to the prosecution modifying its list of witnesses to be called on numerous occasions, to the prosecution adding new allegations against Drago Nikolic, such as the infamous words attributed to him during a conversation which supposedly took place at the Zvolnik Brigade Command involving witnesses PW-102 and PW-108. To the prosecution delaying the disclosure of both the identity of certain witnesses and the evidence they were to provide until the very last minute. I refer inter alia to witnesses PW-101 and PW-108. Despite all of this, Mr. President, the theory put forward by the defense of Drago Nikolic has remained unaltered throughout. That being said, one thing has changed, Mr. President, since making my opening statement. 3 years ago, I said that the evidence would demonstrate that Drago Nikolic did not commit any of the crimes in the indictment, and that by the end of the trial, you would have no chance but to return a verdict of not guilty for counts 1 to 8. Today, on the basis of all the evidence admitted on the record, it is evident to us that the prosecution has failed to meet its burden of proof, and we are confident that Drago Nikolic does not incur individual criminal responsibility for all of the prosecution's allegations in the indictment, except for a few allegations in relation to the events which took place in Oraovac on 14 July 1995. Mr. President, this is not easy to say, and it is certainly not the norm for counsel before this tribunal to say that their client may incur liability for any of the violations set out in the indictment. Cutting to the chase, however, we are not blind to the evidence. The evidence has shown that Drago Nikolic was close enough to what happened in Oraovac on 14 July 1995 to possibly incur criminal responsibility for what happened there. Of course, it will be for the trial chamber to determine the true extent of Drago Nikolic's involvement in these events. However, two preliminary remarks must be made in this regard at this stage. Firstly, it is evident on the basis of the evidence on the record that the responsibility of Drago Nikolic for what happened at the school in Oraovac on 14 July 1995 does not even come close to the prosecution's theory of the case, which clearly is not supported by the evidence. Secondly, it is a reality that the proceedings against Drago Nikolic could have ended much sooner if he had been properly charged and if the prosecution had not attempted to put everything on his back simply because this is Srebrenica and no one should get off lightly. Moreover, looking at the manner in which the prosecution handled the plea negotiations with Dragan Obrenović and Momir Nikolic, pleading guilty was simply not an option for Drago Nikolic. Despite his understanding that he may incur criminal liability for what happened at the school in Oraovac in July 1995, there was no chance that Drago Nikolic would accept to fabricate evidence and or to create a narrative to please the prosecution, as the evidence reveals Dragan Obrenović and Momir Nikolic did when they pled guilty in the Blagojevich case in exchange for leniency. In my opening statement, I said that the statement of facts provided by Momir Nikolic and Dragan Obrenović as a result of their plea negotiations with the prosecution were replete with lies. The evidence adduced over the last 3 years demonstrates my point beyond any doubt. This, Mr. President, is in our view a major consideration in this case. History deserves better. The International Tribunal deserves better. The victims of Srebrenica, and more importantly their families, are entitled to know the truth, as well as what really happened in July 1995. Not the lies of officers looking for leniency. In this regard, it is our submission that the statement of facts provided by Momir Nikolic and Dragan Obrenović, which have been admitted in evidence in this case, cannot be attributed any probative value, and I will come back to this later. For now, suffice it to say that the alleged responsibility of Drago Nikolic, once you will have disregarded the incriminating evidence found in the statement of facts provided by Momir Nikolic and Dragan Obrenović, that you will have no other choice but to conclude that the prosecution's case against Drago Nikolic has been entirely defeated. To put it bluntly, Drago Nikolic is simply not the man whom the prosecution would like you to believe he is. Another very important consideration we wish to bring to your attention at this stage is that despite the soaring gravity of the crimes committed in and around Srebrenica, as well as in the area of Zvornik, in respect of Drago Nikolic, we are talking about a period of 24 to 36 hours at the most in the life of a man. Needless to say, this is neither a defense nor an excuse for what happened during that period. However, it is an important fact which, if duly considered, will allow the trial chamber, in our view, to properly assess the true responsibility of Drago Nikolic in the context or in the circumstances ruling at the time. In this regard, the fact that the prosecution has not adduced any evidence related to the alleged responsibility of Drago Nikolic other than for the limited period of mid-July 1995 is significant. Moreover, in our submission, the evidence reveals that Drago Nikolic was in no position to influence the course of events once he realized what was happening in the area of Zvornik on 14 July 1995. The evidence also reveals, as will be argued later, that due to his rank and position, and considering the attitude of his superiors towards him, including, amongst others, Vinko Pandurevic and Dragan Obrenovic, Drago Nikolic would have been unable to become a member of any joint criminal enterprise, the members of which included or would have included the commander of the army, as well as other senior level officers. This is probably why, Mr. President, as I discussed so many times with my colleagues during this trial, it appeared as though during the trial, everybody wanted a piece of Drago Nikolic. That being said, I move to this next part of our argument. Before I move to the next part, allow me to invite the members of the trial chamber to turn to their right and to look at the man who is sitting there, Drago Nikolic. For the past 3 years, Mr. President, Drago Nikolic has been sitting in this courtroom, hearing all the witnesses who have testified, and you have seen his reaction to the evidence. Even before we say anything more about him, I invite the trial chamber to consider both the demeanor and the body language of Second Lieutenant Drago Nikolic sitting amongst a group of superior officers throughout this trial. This, Mr. President, is another theme we intend to address during our closing arguments, namely the significant differences which exist between Drago Nikolic and the other co-accused in this case. Finally, it is necessary at this stage to draw the attention of the trial chamber to a major deficiency affecting the prosecution's final trial brief. When I read this brief for the first time, Mr. President, I had the impression of reading a new and improved version of the prosecution's pretrial brief, supplemented here and there by new footnotes. What is most significant, however, is the absence in the prosecution's final trial brief of any critical approach regarding the evidence which was admitted during the last 3 years. If something was mentioned by a witness and it was incriminating on any of the co-accused in this case, it was referred to by the prosecution in its pretrial brief. Moreover, the prosecution simply ignored reliable and probative evidence adduced by the defense. As a result, what may appear prima facie as being a strong case against Drago Nikolic will end up being an empty case once the trial chamber will have assessed the evidence and determined what probative value, if any, can be attributed to it. This, Mr. President, we are confident the trial chamber will do. With this in mind, I take this opportunity to bring back the boring figure, which I used during my opening statement 3 years ago. We promised on that occasion that despite the seriousness and the gravity of the allegations against Drago Nikolic in the indictment, the trial chamber, if it put its mind to it, would be able to identify his true involvement in these events. This is what the boring picture is all about. Whether you see the young lady or the old lady first is not important. There are more than one way to look at the prosecution evidence. What is important is that at this stage, you are able to see the lady that you did not see 3 years ago. On this, Mr. President, I move to the second part of our closing arguments, dealing specifically with the duties and responsibilities of Drago Nikolic. What I wish to do at this time is to address certain issues concerning his duties and responsibilities in the light of the specific prosecution arguments in its final trial brief. A lot of evidence has been heard during this trial concerning the duties and responsibilities of Drago Nikolic, in his capacity, of course, as security organ of the Zvornik Brigade. Firstly, I refer the trial chamber to our submissions in the Nikolic final trial brief at paragraphs 345 to 395. Secondly, I note that the position taken by the prosecution regarding these duties and responsibilities is very similar to our own position. In fact, we agree on many issues in relation to this topic, which is not surprising, of course, because the duties and responsibilities of security officers were clearly defined in the rules and regulations which were applicable at the time in 1995. Moreover, the views expressed by our own security expert, Petar Vuga, are very close to that of the prosecution's expert, Richard Butler, on this issue. In fact, in this courtroom, only one person, namely Vinko Pandurevic, disagrees concerning the duties and responsibilities of Drago Nikolic as security organ of the Zvornik Brigade. And this is one of the topics I will be addressing later on. That being said, Mr. President, there are at least 3 issues concerning the duties and responsibilities of Drago Nikolic on which we disagree with the prosecution, and we respectfully submit that the prosecution is wrong in this regard. These issues include the power and ability of Drago Nikolic to issue orders to members of the military police company, the responsibility of Drago Nikolic for the treatment of prisoners of war, and the role of Drago Nikolic concerning the exchange of prisoners. On the first issue, I refer the trial chamber to paragraphs 2595, 2596 of the prosecution's final trial brief, where it is stated, once the commander issued an order, Nikolic would provide directions and instructions to the commander of the military police company on how best to implement the commander's orders. Even though this may appear to be a benign issue on its face, it is evident that the prosecution's understanding of this sentence goes well beyond the correct interpretation of the applicable rules. It is evident also that the prosecution takes this position with the sole aim of applying it to the events which took place at the school in Rochevich, with the view to increasing the individual responsibility of Drago Nikolic. But this is an erroneous interpretation of the applicable rules, which recognize that Drago Nikolic, or rather that staff officers, do not tell commanders what to do. In this regard, the prosecution has it right when stating in its final trial brief that Drago Nikolic did not have any command authority of his own over the military police, despite the impression left on some members of the military police company, and that he was actually passing on the orders issued by his commander. The prosecution also has it right when stating in its final trial brief that Nikolic always operated under the derived authority of his commander, Pandurević, or in Pandurević's absence, Dragan Obrenović. The contentious issue is where the prosecution states that Drago Nikolic was giving instructions and directions (26424, 26425) testified in the same way. Secondly, in passing on his commander's orders to the commander of the military police company, Jasikovac, Drago Nikolic did not give instructions and directions. His involvement on the basis of his role, his advisory role to the commander in respect of the military police, was limited to providing specialist advice and recommendations on the use of the military police company to his commander, not to the commander of the military police, to the commander of the unit, to Vinko Pandurević. I refer the trial chamber on this issue to the submissions of my colleague Ivanovic on Monday. In other words, when Drago Nikolic passed on the orders of the commander to Jasikovac, he did not tell him how to implement these orders or how to use the resources at his disposal for this purpose. And neither did he provide, as the prosecution would like you to believe, without the support of any evidence, directions or specific instructions in this regard. Also, if and when orders were passed on directly by the brigade commander to the commander of the military police company, for example, when dealing with combat issues in which Drago Nikolic had no involvement whatsoever, as confirmed by Vinko Pandurević himself, transcript page 31684, Drago Nikolic certainly could not interfere and give directions on how to implement the commander's combat orders. All of this was made clear by Petar Vuga in his expert testimony, transcript 23315 to 23317. See also 23453 and 23457. Once again, the only reason why the prosecution takes this erroneous position is to attempt to demonstrate that Drago Nikolic was directing the show in Oraovac, which is not what the evidence reveals. There was no show in Oraovac, and Drago Nikolic was not directing anything that was going on there. I now move to the second issue I wish to address, the responsibility of Drago Nikolic for the treatment of prisoners of war. Now, I use prisoners of war, and everybody in the courtroom uses this term, even though it should not be used in the context of a non-international armed conflict. So sometimes I say prisoners, and sometimes I say prisoners of war, but let it be known that I simply refer to those people who were captured as a result of the hostilities. The prosecution advocates the view that through his professional management of the military police, Nikolich's role also included responsibility for prisoners of war. Paragraph 2634 of the prosecution final trial brief. We strongly disagree with the prosecution's position, which is simply wrong, both factually and legally. In support of its position, the prosecution refers to paragraph 3.19 of the Butler Brigade Command Responsibility Report, that is P684, as well as to Exhibit P707, Service Regulations of the SFRY, Armed Forces, Military Police. On this basis, the prosecution notes that the military police take part, and I underscore, take part in providing security for prisoners in camps for prisoners of war. The prosecution also notes that the military police may also, upon a special order, escort prisoners. We agree with those references or those provisions. Paragraph 3.19 of the Butler Report also provides that at the brigade level, the brigade commander was responsible to ensure that the provisions of the 1949 Geneva Conventions were strictly complied with regarding the treatment of prisoners. We also agree with this statement. However, from these references, the prosecution goes on to state, without any support, that the task of the military police include the treatment of prisoners. This is nowhere mentioned. This, Mr. President, is clearly incorrect. Nowhere is it mentioned in the applicable provisions of the rules and regulations concerning the duties and responsibilities of the military police that they are responsible for the treatment of prisoners. As revealed by the evidence in this case, the overall responsibility for the treatment of prisoners rests, as for everything else, first and foremost with the commander of the unit holding these prisoners. Moreover, within any unit holding prisoners, many organs are involved in the handling of the prisoners, including, for example, the intelligence organ for interrogating the prisoners of war, the logistics or rear services for transport, food, water, and other supplies, the medical service, the personnel and administration service for the mobilization of accommodations if needed, and, yes, the military police to provide security in and around the facilities where prisoners are held. The evidence in this case reveals that the military police of the Zvornik Brigade did exactly what the rules and regulations provided for. They provided security around some of the facilities where the prisoners were held, namely at the schools in Oraovac and Rochevich. Testimony Ivanovic, transcript 14562. Testimony Birchakovic, transcript 10764, 10765, and even testimony PW 143, which is relied upon heavily by the prosecution in other circumstances, transcript 6586. It follows, Mr. President, that the military police is not responsible for the treatment of prisoners of war. And then it is incorrect, of course, to argue that Drago Nikolic, through his professional management of the military police company, was responsible for prisoners of war. It must also be recalled in this regard that in July 1995, Drago Nikolic was solely the security organ of the Zvornik Brigade, and that he had no responsibility for the gathering of intelligence. In other words, Drago Nikolic was not involved in the interrogation of prisoners of war, and he did not have any professional reason to be personally in contact with the prisoners held at the school in Oraovac in July 1995. Once again, the prosecution attempts to demonstrate that in his capacity as security organ, he had a responsibility for the handling of prisoners, which goes way beyond his de jure duties and responsibilities in July 1995. As for de facto responsibilities, as for orders which would have been issued to him to be responsible for the prisoners during that period, there is no evidence to that effect. This is directly related to the oral submissions made by my colleague, Mr. McCloskey, on 2 September, when he said, transcript 34046, that one of the things required for the accused in this case to be guilty is that they consciously made the decision to disregard their duty. Consequently, it is highly significant that Drago Nikolic did not have any specific duty or responsibility for prisoners held at the school in Oraovac, or at any other school for that matter. His responsibility was to see to it that there was some security, nothing more. I move to the third issue on which we disagree with the prosecution, and I refer to the prosecution final trial brief, paragraphs 2650 and 2658. In these paragraphs, it is suggested that Drago Nikolic would have known, again, the words are important, would have known, that the prisoners taken to Oraovac were not going to be exchanged, because he had been involved in the negotiation of prisoner exchanges since 1993, and he knew the standard procedure for detaining, registering, interrogating, and exchanging a prisoner. My colleague from the prosecution, Mr. Mitchell, reiterated this argument during his oral submissions. This position is erroneous, both factually and legally. Firstly, Drago Nikolic did not have any duty or responsibility in relation to the exchange of prisoners of war, a fact which was confirmed by witness Novica Simic, transcript 28571. While the prosecution relied on the testimony of Novica Simic, paragraph 2650 of its final trial brief, to describe the procedure for exchanging a prisoner, it omitted the part of his testimony where he makes it clear that, quote, the exchanges are carried out by the main staff of the VRS, and there are also commissions that were organized at the corps level. The brigades did not get involved in the exchanges. This was also confirmed by Dragutinovic, transcript 12713, 12714, as well as by Vinko Pandurevic in his report of 20 July, that is P350, asking the Drina Corps for assistance in dealing with prisoners. As for Exhibit 3D, 7D, 454, the Zvonik Brigade Command Report number 57, it merely describes one incident in 1993 when Drago Nikolic, at a time when he was both the chief of intelligence and security, was involved in the exchange of one recently captured prisoners from Rocevic, acting with and in support of his commander, Pandurevic. Consequently, Mr. President, there is no evidence on the record establishing either the involvement of Drago Nikolic in prisoners' exchanges since 1993 or his detailed knowledge of the applicable procedure. The prosecution has adduced no evidence in this regard, yet they would like you to accept its proposition at face value for the purpose of drawing a negative inference against Drago Nikolic. Clearly, Mr. President, the prosecution is pushing the envelope too far. I move immediately to part 3 of our submissions today, which has to do with assessing the evidence on the record. And the first issue is the credibility of witnesses. I wish to begin by recalling what my colleague for the prosecution said 3 years ago in his opening statement. He warned the trial chamber that he expected some of his witnesses to lie. He actually referred to one of his own witnesses as a bold-faced liar. Transcript 386. Let me also recall the words of one of my colleagues from the prosecution who said on 3 September, when referring to witness Srećko Achimović, and the fact that this witness, according to the prosecution, a fact with which we agree, tried to minimize his involvement in the events which took place at the school in Ročević. My colleagues stated that, of course, does not mean that everything he said is not true. The question is, Mr. President, what probative value should be attributed to the testimony of a witness when there are reasons to believe that he did not tell the truth in respect of one or more material elements of the evidence he provides? Another way to put the question is whether it is possible to pick and choose in the evidence provided by a witness between what can be attributed weight and what is not deserving of probative value. This is an important question because this is what the prosecution does for a number of witnesses who are referred to in its final trial brief. When they like it, when it suits their case, it should be attributed probative value. When it doesn't, then of course the witness is not to be believed. A good example of this is witness Birčaković. I will come back to this later. As very well put by my colleague Stojic, the prosecution cannot have it both ways. While it can reasonably be said that witnesses who appear before this trial chamber tried, at least to a certain extent, to distance themselves from the events which took place in July 1995, it does not mean that these witnesses were not truthful, and we are confident that the trial chamber will have no difficulty in identifying the credible and reliable witnesses amongst them. However, it is our submission that when there are good reasons to believe that a witness did not tell the truth about one or more material facts disputed by the parties, the trial chamber must exercise extreme caution before attributing any weight to his evidence. This brings me to the issue of corroboration, which a word we see so many times in the prosecution final trial brief. While there is no legal requirement per se that the testimony of a witness be corroborated before it can be attributed probative value, it is nonetheless our submission that this is necessary when dealing with a witness who either has a past record of not telling the truth or whose evidence is contested on the basis that he obviously did not tell the truth. This is all the more true when the evidence provided by such a witness is the sole evidence on the record concerning a fact which must be proved beyond reasonable doubt. In such cases, we respectfully submit that the evidence offered by the prosecution as corroboration must be both reliable in itself as well as independent from the evidence supposed to be corroborated. This, as will be argued throughout our submissions, is one of the main defects in the prosecution final trial brief, whereas the evidence adduced to corroborate the testimony of certain witnesses is not reliable, is not independent, and very often both. I refer specifically to the testimony of witness PW 168 in this regard. More importantly, it is our submission that the prosecution's case against Drago Nikolic rests on evidence provided by witnesses who are so unworthy of belief that no weight whatsoever can be attributed to their testimony, leading to only one conclusion, one possible conclusion, that the prosecution failed to prove its case. This is what guided the construction of the Nikolic final trial brief. In our view, it is not possible to adjudicate this case and determine if the prosecution has met its burden of proof beyond reasonable doubt without first assessing the credibility and reliability of certain key witnesses and deciding what probative value, if any, can be attributed to it. Accordingly, we identified precisely 8 key witnesses, namely PW 168, PW 101, Momir Nikolic, Mihailo Galic, Srećko Achimović, PW 102, PW 108, and last but not least, Vinko Pandurević, for whom we made specific submissions concerning the weight that can be attributed to their testimony. These 8 witnesses, Mr. President, are not the only ones who did not tell the truth before this trial chamber. However, what is most significant about these witnesses is the fact that because very little weight, if any, can be attributed to their evidence, the prosecution's case against Drago Nikolic falls apart. Without repeating our detailed submissions in the Nikolic final trial brief, I will say a few words about each of them. Mr. President, I see that there's only 5 minutes, and the first witness I'd like to make some submissions about is likely to be for more than 5 minutes. With your leave, I would like to stop here and continue in the morning.
Thank you, Mr. Bourgon. We'll do that.
Thank you, Mr.
We'll
President.
continue tomorrow morning at 9.
All rise.